Could you please state your name and the position that you're seeking?
My name is Andrew Lloyd, and I am running for the District Court, 271st District Court over Wise and Jack counties.
So, our first question is, what qualities do you have which you believe will make you the best district judge?
I think the initial quality would be wisdom, which would sound weird. I'm only 51 years old, but that comes with experience and knowledge. My knowledge base is replete with all of the laws and cases that I've handled. I excelled not only in undergrad with a 4.0, but also being at the top of the law school and the dean's list. But since then, have practiced in virtually every area that this court will handle. And that gives me the broad experience to get me there. More importantly, with wisdom would be discernment to make sure to evaluate those that come in front of me. There will be evidence, there will be witnesses, there will be a credibility issue to determine. And you need to be able to understand people and how they react and speak and watch for cues that will give you an idea as you pay attention to what God would tell you as to whether they're being truthful or not. I think those two things hand in hand and my ability to be impartial and speak with the everyman, I think sets me up to be a great judge. In addition to the fact that I'm honest and trustworthy, and I've got a great reputation for that very fact. Thank you.
So, how do you perceive your experience compares to that of your opponent?
I can't say specifically what my opponent has done. I can only look back at the history that shows up online. And essentially, my understanding is he's primarily a criminal defense attorney. I have done criminal defense, probably about 15, 20% of my practice. However, I'm also a former prosecutor. So I've seen the law on both sides of that. And I think it takes that broad experience in order to understand criminality and how that jurisprudence comes into the courtroom. But the bulk of what I do is family law, CPS matters, divorces, temporary restraining orders, protective orders, custody agreements, child support, all the yuck that happens to everyone day in, day out. I also do civil litigation, which means contract disputes and land disputes. And I've handled wills and trusts and probate and guardianships. Each and every one of those items comes through this courtroom and, in fact, is the bulk of what is heard in a general jurisdiction court. So my broad experience, frankly, is going to get me there a lot quicker than him. You can't take the time to learn about your daughter's divorce case and look up the law and the nuances in family code if you've never done it before. So I'm there and ready to go day one.
What is your philosophy on bail and pretrial detention under Texas law?
Well, the philosophy would be first and foremost to follow the law to the T. It's not up to me to just make a decision and be willy-nilly about what I want to do with bail. But the first consideration is to make sure to protect the public, to make sure that the bail is lawful, that it's not such an egregious number that it doesn't stand up to appellate law. But also to make sure we protect people and give them an opportunity to post bail. Crimes shouldn't be committed, and police officers don't take people off the street lightly. And if they've done it wrong, then they'll have a trial and we'll figure that out with evidence. But bonds need to be posted in a manner that will keep people there, that will keep our streets safe until they can either bond out or have their trial and their day in court. Those bail bonds and those issues are set between me and the JP courts and others that will basically take the calls in the middle of the night. And we will work together, as I've talked with all the JPs and those who are hoping to be JPs right now, about what we need to do to make sure that we're matching in our ability to consider high bonds and low bonds. Repeat offenders, we need to double and triple that thing up. We don't need crime in our streets.
How will you ensure that every litigant, regardless of background, wealth, or representation, receives a fair hearing?
This may come off trite, but honestly, that's an easy answer. I treat everyone the same no matter what socioeconomic background they have. Fact of the matter is, my wife comes from a Hispanic family. My mom was married to a black guy. I've got multiple friends in every race. I literally don't care. None of that matters to me. What matters is that people follow the law. I have been a certified mediator for essentially the tenure of my law license, which means that I take all walks of people and I settle their conflicts and cases, no matter who's got money and who doesn't. I've been on the list to help people that are indigent in CPS matters and criminal defense and civil litigation and tax matters. And I treat every client respectfully and the same. They get a Mr. and a Mrs. from me all day long. There's no requirement that they do something or owe me something or have to perform or don't get my full service. I've been doing that throughout my career and have a reputation for that. I can't see that ever being an issue in the courtroom. Frankly, we treat all humans as our brothers and sisters on this earth equally, as we should. They will determine whether or not they're going to get the brunt of the law or not.
And how do you balance the letter of the law against the perceived spirit of the law when rendering judgment?
Easy answer, because the Texas Code of Judicial Conduct requires me to simply follow the letter of the law. There is no spirit of the law per se. It's a great statement that we use colloquially, but the truth is, well, number one, I'm not a Democrat, so I'm not going to be an activist and get on the stand and do things that shouldn't occur. And I only say that because we've seen that in the news. I don't know any of those people personally and couldn't say that that's how they act. But we've seen enough rhetoric out there that there are judgments made because a judge wants to be political or make some sort of active claim. That's not what we're mandated to do. Fact of the matter is, we have to follow the law the way it's written. Precedent, statute, Constitution of Texas, and the United States. We follow the law and the cases that come before us. So it's letter of the law. If there's interpretation, it'll be based on what the legislature said. Otherwise, follow the letter of the law.